What if tomorrow you woke up and you were being sued? Not because you did something evil, not because you hurt anybody. Nope, it's just because you were the easy target. So here's the what if, and it happens every day. By the way, the scenario I'm going to give you, I did a video almost on this exact thing. There was a defense attorney on, and there was an $87 Costco parking lot tap that became a $3 million frivolous lawsuit. So the what if scenario is you're driving and there's an accident. Maybe it's you, maybe it's your spouse, maybe it's one of your kids, but there's a small accident with a car that has 3 people in it. They seem fine, but later you find out they all went to a doctor and they claimed that they were horribly hurt. So the billboard lawyer sues you for $2 million each, $6 million lawsuit. Now what happens next is the part people don't understand. Before the lawyers spend any real time on the case, they're going to run a quick asset search because lawsuits are a business. And they're asking one question: are you collectible? Or is this just, hey, we're going after the insurance? So the big question is whether you look collectible, because if you do, your case gets bigger, uglier, and more expensive fast. So in this video, I'm going to show you how to become an invisible investor so you don't look collectible. When the billboard lawyer's PI is searching you in the public records, they find nothing because you're invisible. Now, you're not invisible to the IRS, you're not invisible to your bank or your lenders, they can still see you. What I'm talking about is being invisible in the public records, invisible to lawyers, snoops, ex-spouses, people who you do not want to know what you own. We want to be invisible to those lazy searchers, the scam artists, the shakedown lawyers. We want to be invisible to the first pass screening that decides whether or not you are a deep pocket. And I'm going to cover both sides of this type of protection. Outside liability means somebody sues you personally and tries to take your stuff. And inside liability, meaning something happens inside your rental or business and they try to reach out to your personal stuff. In the end, I'm giving you a free download called 3 Steps to an Invisible Investor Strategy. It was written by my partner, Clint Coons. It's absolutely great. It's simple, it's practical, and it's a checklist version of everything we are covering. I'm going to put it in the show notes. And if you want, there's also an optional strategy session link where you can map out the situation for yourself based off of your facts. All right, let's get into it. First, the mental model. If you understand this, the rest of the video becomes obvious because almost all cases settle. It's like 99+%. That's just reality. So the settlement value of a case isn't what the lawyer says it's worth, right? The settlement value is basically this: the size of the claim, and we're going to multiply it by the chance that they win. But we're not done yet. Minus their costs, and then we're going to take that whole thing and we're going to multiply it by the chance of collection. You don't see homeless people getting sued very often, right? Because there's not a good chance that they're going to collect. This part is the killer, the chance of collection. Because winning a judgment that you cannot collect is not a victory. It's paperwork. So your goal as an investor isn't never get sued. Lawsuits are just a fact of life. If you drive, if you have kids who drive, or if you have a business, you have employees, you own rentals, there's always a risk. And just remember, there's over 70 million cases filed each year in the United States. A big chunk of those are tort claims looking for money. So you're going to get up close and personal with the U.S. legal system at some point, unless, this is a big unless, you take active steps to minimize those chances. And I'm not saying don't have kids and don't have rentals and hide in the basement. No, that's not practical. I'm saying that you can take simple steps to keep your assets invisible, and that doing so will prevent most lawsuits and help make claims that do happen go away quickly when they occur. Be invisible. It's called security through obscurity. So here's our goal. Make recovery look uncertain. Make the collection path annoying. Make the case smaller. And make the bad cases go away early, or better yet, avoid them entirely because you don't have a big, massive sue me sign taped to your back. And that's what invisible means. So let me break this down to you so it makes better sense using real life examples. Now I'm going to use a simple ladder. I'm going to use 4 levels across a bunch of main categories, like your personal residence. I'm going to go over things like checking, savings, brokerage accounts, called safe assets. We'll go over rental properties, and we'll go over businesses. And we're going to use real world scenarios because that's what makes this stick. So here's the ladder. Number 1, owning things in your just individual name. This is the most visible, I'm going to call it rung on the ladder. It's the easiest to target. Level 2 is put it in a basic structure like a trust or an entity so your name stops popping up everywhere. This is privacy in containment, and it's actually very easy. Level 3 is you strip or block exposed equity and you create real friction. So now even if they find it, it does not look worth chasing. Level 4 is you add distance. It's holding structures and higher protection layers so the chance of reduction drops even further. And that's where serious investors, are always going to end up. And here's the important part. The ladder is not one size fits all. Not every asset needs level 4, but every asset should not be stuck at level 1 because level 1 is what gets you picked. Level 1 is going to be painful if something happens. And level 1 is basically how people lose everything. Whenever you hear those stories of somebody that got wiped out, it's because they had everything in level 1. And so let's get back to our what if scenario. We had the accident. Scenario 1, you or a family member has a car accident, right? It was nothing serious, or so you thought. And then there was 3 people in the other car and they all said they were okay, but then you get served with a lawsuit where each one of these people is suing you for $2 million. That's a $6 million lawsuit and you do not have enough insurance to cover it. Think it doesn't happen. Again, go to watch my video, the $87 fender bender that became a $3 million lawsuit. It happens every single day. Now they're running an asset search and they're hunting for public record targets, easy collection targets. And let's start with the biggest bullseye for most people, and that is your primary residence. Let's assume that your house, your primary residence, is worth $1 million. And you own it free and clear because you listened to Dave Ramsey, right? Maybe you bought it 10, 30 years ago, something like with no mortgage, no liens, it's clean title. That looks like a vending machine to an aggressive lawyer or to a scammer. So here's the ladder for your home. You ready? I'm just going to go over each one of these. This is 1, 2, 3, and 4. Level 1, the house is in your personal name. What does the lawyer see? Your name is on title. It's a public record. It's easy. So the next question, now they know it's in your name, can they get the equity? Well, that depends on your state's homestead protection, right? Some states protect a lot, like Florida and Texas. It's unlimited. And some states protect very little, like you're going to get basically nothing. Some states are basically good luck to you. But here's the problem. They're suing you if the lawyer sees a paid-off home or a home with a lot of equity beyond the homestead protection. You just became worth chasing because you are now collectible. The lawyer here is looking at collecting $6 million, now knows there's $1 million of equity attached if there's no homestead exclusion. And again, every state is a little bit different, but they're going to be looking at the amount of equity that is available. I've watched this play itself out so many times that it isn't pretty. Foreclosures are absolutely devastating, and doubly so when it's a BS lawsuit. There are other issues of having your name in the public record if you own your home. For example, depending on the industry you're in, you may have patients showing up at your house or clients showing up, vendors showing up, crazies showing up at your home. Or better yet, process servers showing up at your home waiting for you to be having a party, and then they slap you with a lawsuit in front of everybody for maximum effect. You also get to probate the home unless you have maybe you have joint tenancy, and so one spouse can avoid it, a transfer on death or similar. But even that's just kicking it down the road. Level 1 planning is no planning, and it usually leads to horrible results. Level 2 is put the home in a trust structure that gets your name off the deed, like a land trust, also known as a personal residence privacy trust. It's a title holding trust. Call it whatever you want. The point is, the deed shows a trustee's name, not yours. And by the way, you can use an anonymous LLC in Wyoming, an attorney or a professional trustee as the trustee. It does not have to be you. It's not going to have your name on it. So let's just say that we have a street. Let's just say this is 123 Oak Street. If I'm going to take that and put it into a trust, I might set up the 123 Oak Street Trust, held by its trustee, ABC LLC. When I say an anonymous LLC, by the way, I'm usually referring to Wyoming. At our firm, we like to use Wyoming, where we just set it up because nobody can see that you're attached to that property. Now what happens? Well, they don't see it when they search your name. So that same lawyer who, you're getting sued for $6 million, and they're looking around, they say, does Toby have any properties? No, he does not. Now, if they really want to go after me, because this is a $6 million case, they might hire a private investigator and dig a little deeper. Maybe they're going to run a skip trace on you. They follow you, and they figure out where you live, and they find out, hey, you live at 123 Oak Street. Even though it's not in your name, they pull that property record, and at that point, they find the trust, and they may roll the dice to see who the beneficiaries are. This is no longer Toby owns a $1 million house free and clear. It's some trust owns a house free and clear. That ambiguity matters because ambiguity reduces confidence, and confidence is what makes the threat letters get nasty. So if we can cut some of their confidence, it's going to pay off for you. So you've made the home invisible, but the equity is still exposed, right? It hasn't really changed anything. Now, some of you might be thinking about, what about a living trust? Well, for level 2 planning, the land trust is generally held by the living trust. Like, we want to get rid of probates, so no more probates, boom, boom, boom. We have strong credit shelter protections for beneficiaries in that case, and at least you have a plan. All the while, the property is no longer in your personal name. For a lot of you, that is sufficient, by the way, because maybe you have homestead protections. Again, Florida and Texas are unlimited, or maybe you have large loans against the property and you have very little equity. Whatever the case, level 2 isn't bad. It may work for a lot of you, but for others, you have a bunch of equity. Again, let's say you own the house and you got $1 million worth of equity and you're worried about it. A different level of protection may be more appropriate. So let's go to level 3 and add a legitimate lien position ahead of a future creditor. This is important. As they always call it, first in time, first in right. If you have a lien that's already filed against that property, guess what? Those lawyers chasing after that equity are going to be waiting in line. And this is what we call equity stripping. And I'm going to say it plainly. Creditors don't chase assets. They chase equity. They want to sell the house and get a bunch of cash. So level 3 is where you stop thinking like an investor and you start thinking like a plaintiff's lawyer. If a private investigator pulls the title for this property, what do they see? They see the home, yes, but they also see liens. And if there's a real lien ahead of them, the equity available looks smaller. Case goes down. Remember this little thing? Chances of collection goes down. Smaller equity equals less to get. Lower settlement value. So this is important. If you do anything like this, it does have to be real. So real documents, real terms, real payments, real bookkeeping. This is a situation where you're using your own LLC and maybe you're loaning the money to yourself to buy the property and the LLC is filing a lien. You should have payback terms and things like that. Now this is what's weird. One pocket is the LLC, one pocket is you. You are not filing tax returns on this. You're not having to do a bunch of crazy stuff. But if you play games and you don't do the paperwork, the court can unwind it. So this is not cute. This is planning. So let's go back to our plaintiff's lawyer who is pursuing the $6 million claim. The most they can get is the equity in that property. So if now we have $900,000 lien against it, what's our equity? We're like at $100,000, right? It goes down. And depending on your state, that maybe there's nothing there for them. If there's very little equity, there's nothing for them to get. And 99 times out of 100, they're not going to pursue it. Level 3 works like a charm, but not everybody is willing to put the documentation into play and follow it. A lot of people use friendly liens as more of a, I'll call it a smoke screen than anything else. It's still very effective, but it won't work if push comes to shove. That's where a higher level of protection might make sense, and that's where we get to level 4, is we're adding distance, where, and this is always, we're looking at it where appropriate. So even if somebody wins a judgment, the path to your equity is long. We want it to be long and expensive and uncertain. This is where serious asset protection planning shows up. You would use an equity protection trust. We'd still use the land trust in conjunction with the land trust. We'd use the equity protection trust in conjunction with the land trust. So I'm going to call it an EPT. And we still have our land trust. So it's still in Oak Street. You're still having a nominee trustee, but we're taking the beneficial interest and we're going to be putting it into an equity protection trust. So the easiest way to look at this is the equity protection trust in conjunction with the land trust ensures the equity is untouchable. An equity protection trust is just a Nevada asset protection trust. It is a bazooka, guys. Nobody can get through these things. We're talking about ex-spouses, even child support can't get into a Nevada asset protection trust. And the Nevada asset protection trust is simply created, this guy right here, is simply created to hold the beneficial interest in the land trust, similar to what we were doing with the living trust. Now, I know it sounds complex, but this whole structure, if we put this in place right here, has no tax returns, no filings with any state, and has what is quite possibly that NAP, the Nevada Asset Protection Trust. It's a credit shelter trust in the state of Nevada. You could use them in any state. We're just going to make it under Nevada law. We're going to make it here. It's quite possibly the best asset protection in the United States. The property would remain invisible behind that land trust. The beneficial interest in that land trust would be held by the Nevada Asset Protection Trust. That's it. You're one and done. This type of planning is appropriate for people with a ton of equity in their home, something that is not protected by a homestead. And so as a starting point, I would say that you would have to have at least $250,000 in equity in your house before you were deploying level 4. There are other options as well, like just using LLC or something like that. Not my favorite. I tend to like the trust route because we don't lose our 121 exclusion. We still have our homestead exclusions, yada, yada. Like we still want to get all these things without undoing. But the point is that we take active steps to ensure your home could never be sold to pay off a lawsuit. And this type of planning needs to be done before there's any claims out there. This is not something you do after the case. So you can't do this after an accident. They have fraudulent conveyance and voidable transaction rules and things like that. So this cannot be done after the accident. It's not done after you get the demand letter or you get sued. It has to be done before. So back to our example with the plaintiff's lawyer, he's pursuing $6 million of claims. Even if they were able to get a judgment against you, they would not be able to touch the equity in the home. And this is the point to this type of planning, to make it so that no plaintiff's lawyer in their right mind would go after this type of asset. It forces settlements before you end up wasting a lot of time and money. and that's the home ladder. It's the same house, same lifestyle, same tax treatment, but 4 completely different options to reduce collectability. Now let's go to the most underrated targets, the stuff that people love to put their ears back and take. And I'm talking about your checking account, your savings account, and your brokerages. Those brokerages can be really tasty. We call these safe accounts because owning these types of assets do not actually create liability for you. So unlike rental real estate, where owning the asset creates liability, like a tenant could sue you, no, you're not going to slip on a share certificate or on cash and get sued. Like, it's not going to cause a lawsuit. So they're safe. So we call these types of accounts safe assets. Safe assets oftentimes get ambushed out of nowhere. So we've all heard these stories, right, of somebody's account being garnished, just disappearing overnight, and this is why. I'm going to explain, going back to our scenario. Same accident, same 3 plaintiffs, same $2 million lawsuit each for a total of $6 million. Now we're just going to go over level 1. The safe accounts are in your personal name tied to your Social Security number. If the plaintiffs get a judgment and they know where you bank, which they're going to discover it, and they garnish the account, they're just taking it. They get the financial institution to literally just hand it over to them. And banks and brokerages don't debate philosophy, whether that was a real lawsuit, it was a good, nope, they just freeze the money, move the account over if there's a garnishment. And even if you ultimately unwind a wrongful judgment or fight it, you're now fighting uphill because your money is locked. Level 1 is exposure. Level 1 is also where we hear about somebody who is unaware that somebody's even pursuing them. Sometimes it's a state agency, a taxing authority. I've seen that a ton of times. Or a plaintiff who never actually served you. I've seen that, where they'll certify, oh, I served this guy, he never responded. They get a default judgment against you, and they go out there and they garnish your money. And the way you find out is the money's disappeared from your account. Where did my money go? I'm trying to pay my bills and my account is empty. In the case of our plaintiffs, they would simply garnish your account and have the bank or financial institution turn that money over to them. Level 1 accounts, easy to collect. And that happens because your name and Social Security number are on that account. So if you want to keep that from happening, you got to change that fact. And that's where we go to level 2. You put the safe account into a privacy trust with an EIN. And by the way, your checks still look normal, but the account title is no longer you personally. This is the most effective thing to keep annoying things like garnishments and surprise suits or somebody pursuing an old debt from simply going in and claiming your account, because your account is no longer in your name. It's now in the name of a trust with a separate EIN. So this is, again, I could call this the Toby Trust. You can get an EIN for it with the federal government, and now it's no longer in my personal name under my social. It's literally in a different name. And by the way, my checks could still say my name on it as long as I'm a signer. But here's the thing. There's no asset protection at this level. This is merely smoke and mirrors. If our plaintiffs with $6 million lawsuit came after an account held in a privacy trust, they would ultimately be able to reach it. So if you want to protect those types of assets, those safe assets, you're going to need something stronger than just this level 2. You're going to want to start using our level 3. And what is level 3? Level 3 is using an LLC. The best example I can give you for level 3 would be using an analogy. So let's say you're walking down a neighborhood street at night, like we've all done it, and all the houses are all lit up. You used to always think about Halloween and stuff. You could see inside the window, everybody's having a good time. You could practically, you could just see right through all these houses. But now imagine that somebody had their house wide open. The front door is open, and there's a big pane window that you're walking by, and you can see right into their house. And you don't see anybody, but there's a huge pile of cash on their table right in front of that window. and their door is open. Now, I know you guys are honest, but you're basically begging for problems if somebody can see your money and that door is wide open. An unscrupulous person might just invite themselves into the home and help themselves to your cash. Boy, that's a lot of cash. I'd like some of it. So the first thing you do is close the door and pull the blinds so people can no longer see your cash sitting on your table. That would be number 2. But that's not very protected. You probably want to take that cash and at a minimum, put it in a safe. We're going to put it in an LLC. You're putting that's level 3. Now, you're looking at somebody, by the way, who has had a safe stolen out of their house. Yep, I've actually had that happen to me. It was bizarre. I had contractors come in and 2 weeks later I had a safe disappear. It was empty though because I had contractors in the house and I had taken it all to safe to deposit box. Yeah, but even there, it's still available to people who are willing to break into your house and take the safe. The safe in the home is level 3. It's very effective. But if you have somebody who's really coming after you, who's really interested in getting your assets, it's not going to be enough. So level 3 is using something like an LLC. And depending on your state, a plaintiff could foreclose on that interest and otherwise take the safe. But what if I told you you could take your safe and you could bury it out in the desert where nobody could see it or reach it? And that's what we're getting at when we go to level 4, which is using an anonymous LLC. The difference between level 3 and level 4 is choosing a state that does not list your name anywhere on the LLC in any public records. It also means choosing a state where the sole remedy somebody can get is a lien against that LLC. They can never foreclose on your LLC interest or otherwise take the cash inside that LLC. At Anderson, we use Wyoming LLCs for this task. They are an inexpensive way to keep your name off of an entity and make sure nobody can take that entity away from you. So let's go back to our example. Same accident, $2 million lawsuit by 3 different plaintiffs. You've got a $6 million problem. But on level 2, they see that you own an LLC and they can start to wonder what might be inside. On level 3. On level 4, they see they never even see the LLC. So level 3, they could see the LLC. They see it in the public record and they might be scratching their head and go, can I get to it? Level 4, they never see the LLC. And even if they manage to get a judgment against you, they win. All 3, $2 million bucks, and you get a $6 million judgment against you. They can't take it. They can't take that LLC from you, and they can't force you, they can't get to the cash inside it, and they can't force you to distribute any of that cash to them. And if you're still worried, and you're saying, well, that might not be enough, I have real exposure, understand that you can add another layer to level 4 even, and that's to add our friend, the Nevada Asset Protection Trust, to prevent anybody from ever forcing you even to get distributions. It also gives you the ability to make distributions, a NAP, a Nevada Asset Protection Trust. You can actually distribute money to your kids, your spouse, siblings, right? I hope that a light bulb is going off for a lot of you guys right now when you realize you can make it towards somebody cannot take your assets from you. That's actually a thing. That is absolutely legal. It's absolutely possible in the United States. Now, you're not doing this to avoid accountability for things that you've done wrong. You're doing this to prevent an unscrupulous lawyer, like in our example, who is taking a frivolous claim and they're turning it into the monster lawsuit. And before you think this is outlandish, understand that the average verdict in federal courts right now is in excess of $16 million. I have friends in the legal profession who have obtained tens of millions of dollars against landlords, other drivers, and other defendants. I'm talking about per case. You do not want to roll the dice in a courtroom battle. So planning is about reducing the chance of recovery because doing so increases the chance of settlement and early on. I'm going to give you an example of two brothers where we had done the planning for them. They ended up in a lawsuit. And I won't give you 2 minutes of the facts because you'd be able to look it up and find it. One brother was our client. Another brother was the client of a prominent LA firm. And they ended up exposed to a multi-million-dollar lawsuit. Both of them were jointly and severally liable, which means they could sue them both and they could collect from either one the entire amount. What ended up happening is they looked at our client and they could not see what he owned. And they literally settled for a peppercorn, what I call is like a small amount, the frivolous value of the case. He was out within months, gone out of this case. The other brother, 4 years of litigation, 7 figures out of his pocket in personal judgment in addition to the insurance. The only difference is one did anonymity and one did not. Now let's pause and shift gears though. Up to now, everything we've talked about is outside liability. Somebody coming after you, me. Somebody sues you personally and tries to reach your stuff. But what about inside liability? Because inside liability is where investors get hurt. They think my rentals are making me money, but what they don't think is my rentals are generating lawsuits and they could take my personal assets. So scenario 2, I'll give you a new one, is based on real life case again. You own a rental property. A tenant invites a friend over. The friend steps on a nail, allegedly, claims it was rusty, claims they got an infection, claims negligence against the landlord. And now they're suing for millions. And this is not a fake case. This is actually something that happened. They didn't even know where's the nail. It sounds ridiculous, but it costs money to defend. And if you're not structured correctly, it becomes a personal asset hunt. So we want to make sure that we're following what we call a rental property ladder in this case. Let's look at them again. Number 1 in rental properties is you own everything in your own name. This is the worst because now the claim isn't trapped inside that rental. The plaintiff can argue their way towards your personal balance sheet. They can get to your home, your checking accounts, your savings, your brokerages. Because you personally own the asset and you personally own all that risk. That rusty nail is putting your home, everything. Like if you're doing level 1 planning, I'll give you an example. A doctor, in real life, they start buying houses out in Indianapolis. They're like, hey, I want to prepare for my retirement at some point. And they start buying rental properties in Indianapolis. And they come in and they say, if something happens, they'll take the house. Like, no, they won't. They're going to take the house and then they're going to come take your other assets. They're going to go and garnish your account. They're going to come after you. They're going to garnish your paycheck. They were making a bunch of money. So that you're exposing your personal case, all of your assets. So that rusty nail in our scenario is literally putting your house and all of your safe assets at risk. And by the way, it's easy to prevent. All you have to do is follow the rungs. Level 2, put that rental into a privacy trust. We use land trusts. And it's just like with your home, but this is just a title holding trust. It'll be titled just like we did with our house, but this is rental properties. The deed shows a trustee's name, not yours. And again, you can use an anonymous LLC in Wyoming. You can use an attorney or professional trustee as the trustee. In our office, my partner's son, Carter, is on an awful lot of these. You can choose to go that route. Just like your home, they can't see that property tied to your name when they search. So the rusty nail guy sees only the entity holding the property. I'm going to call it, we'll call it 123 Oak Street. All right. His lawyer looks around for all the 123 Oak Street trusts that own more properties, and they're not going to see anything because we're going to hold a land trust per property. We're going to name them after that property. So if I had 123 Main Street, I'd just put it in the 123 Main Street Trust by its trustee. They look around and and then they go and they say, hey, but there's a trustee, let's look for them. And they go and they try to find who owns that LLC. It's Wyoming. Your name's not tied to it. Nada. So they look at all the trusts. I'm looking at 123 Oak Street. They see nothing. They look for the ABC LLC. Nada. In other words, they cannot tie you to the property. But we don't want to base our protection simply on making it impossible to see who owns the property or who has an interest in the property, because we want real protection. And this is where, again, we're going to have to go to level 3. So level 1 is owning it in our personal name. Level 2 is a privacy trust and getting it out of our name. Level 3 is putting it into a real liability box. And this is typically our friend, the LLC, a limited liability company. Generally speaking, depending on whether you have financing or what state you're in, we're going to use a trust to entity structure. So we're going to use like the 123 Oak Street Trust, but this time we're going to assign the beneficial interest into an LLC. So let's just say it's well, we can't use ABC, so we'll use DEF LLC. We'll just do that. Put the rental into the liability box. And by doing this, that is the equivalent of having it inside the LLC. So that's generally what you're doing. And by the way, the reason that we do this type of structure, is because depending on your state, you may be able to get protection out of the land trust itself, like in Florida. A lot of states you can't. But you also have transfer taxes, you have due on sale clauses that could get triggered, and you have other logistical stuff. So we're going to use the trust to hold it to avoid that issue. Now, I mentioned Florida. They actually have asset protection as part of a land trust. So technically, you could use just a trust, but we don't necessarily recommend that, as we'll get to when we get to 4. We like to use the LLC because it's so well known to all the judges out there, and it isolates that liability. The courts understand it. Everybody understands what LLCs do. It protects you from liability personally when there's an occurrence on a rental property that is held in that LLC. So if something happens in that property, we want it to stay inside of that LLC. And that's what we're trying to do. We're not trying to be bulletproof. You're trying to prevent spillover. You're simply setting up an LLC, sometimes a trust, in a state where the property is located, and making sure the liability is trapped inside the LLC or trust. So if you're sued by Rusty Nail Guy, you never have to worry about your personal assets because he's stuck inside that LLC. Even though the title is held up here, so he doesn't tie a whole bunch of other properties there and target you for that reason, but he's still going to be stuck inside of that entity. So you never have to worry about your personal assets being at risk. But there is some risk that a plaintiff's lawyer is going to make a claim that they're going to try to do a pierce the veil on this LLC. And they're trying to find out, generally speaking, who the owner is. So our recommendation here is that we add a level 4. And level 4 is creating a holding company. So if you remember our safe analogy, where you're walking down the street and you see the safe, level 3 was having an LLC. But level 4 was having an anonymous LLC in a state where they could never take the LLC away. Well, we're going to do the same thing here. But inside that safe are the LLCs holding the rental properties. So this guy might go into a holding. So a hold LLC, see if I can make that into an H, into a hold LLC. And let's say we have a whole bunch of other LLCs and they're just going down into this holding, perfectly fine. You could have properties all over the place. They're isolated, but they're all held inside of a holding LLC. So even if they can target you, even if they could try to get liability to you, there's nothing for them to get because they cannot take that. And on the same token, if something happens inside of these individual LLCs, it's stuck inside that particular LLC. If they try to find out who owns that LLC, they're going to be disappointed because it's going to be the anonymous LLC. This is how you avoid the breadcrumb trail. Because here's what people don't realize. If you own one rental property in your name, it's easy to find. But if you own 10 rental properties in your name, it's a shopping list for an unscrupulous lawyer or a scam artist. But if you structure correctly, one rental doesn't lead to all of your other rentals. And that changes everything about how you get targeted. So Mr. Rusty Nail is going to be stuck inside of an LLC. The name on his property is going to be a land trust. But if he tries to fight this, like he's going to go into court, he's going to realize that that land trust beneficial interest is simply held inside an LLC. And voila, he's still stuck inside the LLC. And that's how you isolate risk. And by the way, we set up tens of thousands of these structures over the years, and we have never seen one pierced. If you were extremely paranoid, you could add another level by adding a Nevada Asset Protection Trust, just to ensure that even if it's managed to get through your LLCs, because maybe you just failed to follow any of the compliance, no records, no nothing, your record keeping would have to be so egregious that the courts ignored it, which I've never seen happen. It still couldn't come back to you. Okay, one last section, and this is dealing with businesses. And this one can get catastrophic fast. I'll give you an example. You run a plumbing business. Use a real life scenario. A worker forgets to seal piping correctly. Walls get done, everything gets done, it looks all good, and that little piping pops open. And it floods a multi-million-dollar home. This was on the second floor. Strong 7 figures of damage. This is not a small mistake. This is what we're calling everybody's insurance mistake. And here's the business ladder. Number 1, you have a loose structure. You know, everything is tied back to you personally. You're running as a sole proprietorship. I just open up Toby's Plumbing. No entity, no nothing. Maybe I get a DBA called Toby's Plumbing. When the business gets hit, I get hit. There's no difference between me and the business. If limits are exceeded or coverage is contested, even on the insurance, my personal balance sheet is the backup plan. We don't want that. So option 2, prong 2, what are we going to do? We're going to operate inside a real liability box. In this case, you're going to run your business as an entity. It's generally going to be an LLC. Sometimes you're going to run it as a corporation. You could be an S or a C Corp. You could actually be an LLC taxed as an S Corp or an LLC taxed as a C Corp. Anything other than your personal name, and you don't want to be a sole proprietor. I'm not going to get into all the tax nuances for this example. There's some big ones. We're just going to be talking about liability for this discussion. But there are a ton of different options when it comes to taxes to make sure you're getting the most out of your structure. And I'll just say this. Feel free to reach out to us and ask questions or get a strategy session because they're absolutely free. And again, I'll put a link into the show notes, including the link to 3 steps to an invisible investor, and you can request a free strategy session. If we place the business in a box, and then in this scenario, we just had the flooding where the worker flooded out the house. It's the business that's the defendant, not you personally. This is very basic. They're going to go after the LLC or the corporation. And it just amazes me over and over again that people just don't get this. You don't do business in your individual name. Please don't do business in your name. Even if it's a $10,000 a year business, don't do it in your individual name because the liability isn't capped at what you make. It's unlimited. It can ruin you. Level 3. This is a big one. If you have a successful business, then you want to separate the operations from wealth. And this is where grown-up business owners separate the doing company from the owning company. An operating company takes on the day-to-day risk. equipment ownership, maybe it's intellectual property, maybe you have cash reserves, maybe you have other valuable assets. Maybe it's even real estate. They're held separately. So one job site mistake doesn't automatically mean everything you've built is in play. The best example I can give you based on our scenario with the flood is if you want to make sure you're removing the cash out of that business. So we have Toby's Plumbing, Inc., and maybe it's an S Corp. I want to pull the cash out of the business. Or if you're holding valuable assets, a bunch of equipment, I want to pull that out of that business before there is a liability occurrence. So again, I'm going to make this really simple. Let's assume that I'm an LLC taxed as an S Corp. And I have $300,000. I'll make $300,000 sitting in my S Corp. Instead of holding it in that S Corp, you want to follow the same strategies we laid out for the bank accounts, the savings account and brokerage account, and you want to set up a Wyoming LLC to move the money into that. So I could literally distribute the cash out of the S Corp and just move it into that existing structure. The S Corp would not own that LLC that I'm giving you. Like, you would own it. You would own the safe LLC. The money would come out of that S Corp, and before you say, but isn't that a taxable event? No, not on S Corp, not on partnerships. You could even have an LLC taxed as a sole proprietor. I could take that money out. The only one I do have to worry about is a C Corp. But again, we're getting into nuances. It is possible that the business entity would own it under certain scenarios, typically if it was a C Corp. But as a general rule, 90% plus of what I see out there, you would distribute the money out of the business and just keep it out of harm's way. You put it in the safe. Now, if you have that same nasty flood, the plaintiff would only be seeing the insurance. They're not going to try to break through the insurance and get through to the actual company structure or into the company itself, because they don't want a reservation of rights. What you see is people call master pleadings. They're going to plead things that they know the insurance company will pay. If they start going over and say intentional misconduct, they're outside the policy, they would have to know that they're able to collect. And if, again, there's no cash in that business, there's nothing for them to get, they're going to be stuck with the insurance. So remember what our goal is. Our goal is to end disputes quickly and get to settlements fast. The last thing we want to do is give somebody an incentive to try to get past our insurance by making claims that are not covered by insurance, or to make claims that are larger than the insurance so they can go after the assets. We don't want to give them that incentive. A large cash balance on the balance sheet of a business is a surefire way to get people to try to attack that business in the event of a lawsuit. Level 4, holding structures in higher protection layers for the assets that matter. So now we're looking at this again, similar to what we did with real estate. We look at the business and say, hey, we can trap liability inside that business, but what if somebody's coming after and trying to take that business from us? A lot of people believe that a business entity can just be set up in their home state and they have no ability to make it anonymous, and that's simply not the case. At a minimum, your business should be held inside of a living trust so that it doesn't get tied up in a lengthy probate process if you pass or if you're disabled. Most businesses don't survive either of those. You want to make sure that there's something in place. But if you wanted asset protection, you could hold that interest of your business inside another entity, either a Wyoming LLC or Nevada Asset Protection Trust, for example. You're doing two things by adding this level of complexity. Number one, you're making sure that you aren't the individual owner of that business, so that all they have, you don't want them to look at it to where all they have to do is pierce that one business and they can get to you. Now, if they pierce that one business, they're going to end up in a holding company. And that's going to be likely that's outside their state. Number two, you're creating another layer from your personal realm to reach that business. So yes, you can create anonymity in many instances by setting up a Wyoming entity. And by the way, like, you could have it own the in-state entity. So just like we did with real estate, we could do this with a business. So I'll give you an example. Let's say you live in California and you have a California LLC taxed as an S Corp. You're going to believe that your name has to be in the Secretary of State. But what if instead of just setting it up in California, you started off by setting an LLC up in Wyoming and having it taxed as an S Corp, and then having it form a wholly owned LLC in the state of California where it's member managed. So then in the California records, it would have the Wyoming entity listed as the member, and your name appears nowhere in the public records. It all depends on the type of business and what you want, but there are far more options than you probably realize. There are options to protect you from your business and to protect your business from you. And you want to maximize the tax efficiency of the business and the deductions that are available to you, the things that you're pulling out of that business for sure, that could make this, by the way, like you can make the sale of the business tax-free depending on how you set it up and under what code provisions you trigger. You may not realize this, but you can actually sell a business for over $10 million and pay zero tax on it. That's section 1202 of the Internal Revenue Code for C Corps, something many accountants tell you not to do. Don't set up a C Corp, it's double tax. You may never pay tax when you sell it. And that's why it's important to talk to somebody who knows what they're talking about on these things. So again, I'm going to offer you the opportunity to talk to one of our professionals to go over what your options are, and you get to have a free copy of 3 Steps to an Invisible Investor Strategy, absolutely free. I'll put it in the show notes, or better yet, go into the comments, you can type invisible. We'll send you a link so you can download the 3 steps, and you can book an appointment if you want, no obligation. Right, quick reality check. None of this replaces insurance. You never heard me say, don't have insurance. Insurance is always your first line of defense. Umbrella coverage matters, good policies matter. And I always look at this. Insurance pays for the lawyers and the settlements. You want to have the insurance, but the actual structure is what keeps the lawsuits at bay and keeps it from getting really bad. And that's good risk management, and it matters. What we're doing here is making sure that if something happens, your plan doesn't collapse because you left everything visible and easy to reach. Because the best lawsuit is the one that never gets filed. And the second best lawsuit is the one that settles early for rational numbers without destroying your life. I used to call them the 3 a.m.s. You're going to be lying around at middle of the night, and you're going to be thinking of all the stuff going on in, you're going to be, Perry Mason, all the stuff in your lawsuit. You don't want that in your life. You do not want that hassle. You want cases to never happen and to settle really quick if they do. So here's your call to action. Download your free 3 Steps to an Invisible Investor Strategy ebook, absolutely free. Type invisible in the comments, we'll send you the link. And if you want us to help you apply this to your exact situation, your state, your assets, your rentals, your businesses, there's an optional strategy link that you can use as well. And one last thing, if you're sitting there thinking, I'll do this later, remember the hook. What if tomorrow you wake up and you're being sued? This is planning you do before there's smoke. This is not planning you do while the house is on fire. All right, guys, download the free guide and tell me in the comments what you think. Until next time.